Welcome back to Nuskas with Anushka, where every story matters and every connection counts. Today, we are joined by a trailblazer in the legal world. He is a renowned expert in corporate criminality, economic offenses, dispute resolution, commercial litigation, and constitutional law. He is a partner at SRB Ojas, a pioneering firm in litigation services since 1979, and a gold medalist from Pune University. His expertise is forged through exceptional academic achievements and extensive experiences. Get ready for a dose of legal expertise with none other than Advocate Chinmay Bhosale. Welcome,
Thank you,
sir, to
Anushka.
the Start with Anushka.
Thank you. Glad to be here.
Same here. Thank you for joining in. So, dear listeners, today we are diving into three pain points that affect us all individually and as a society at large. And those are bail matters, check bounce cases, and the challenges that we face within our judiciary and the police forces. Also, the best is saved for the last. My final question addresses a universal frustration, so don't miss that and watch till the end. So, before we dive deep into the legal world, if we had to look back, sir, to your younger days, was law always your calling, or did your passion develop over the time?
So, I am that cliched person who belongs to a law family. Generational lawyer, always been around lawyers. And that has inspired and influenced my thought process and my inkling towards law. So, always wanted to be there. It's not that it was a forced choice. Just because I was from a law background, I had to join law. But I remember as a child, my outings used to be to my father's office and sitting below his desk probably and listening what's happening. So way back since then, I am used to this environment, and it came as an obvious choice for me. Rather, my family was not too keen for me to join it, but yes, for me personally, it was an obvious choice.
Okay, great. So, as we spoke about the three topics that we're going to cover today, so let's start with the bail matters first. And
Yes.
so, my first question for you would be that what are the primary factors that are considered by the courts when granting or denying a bail?
Yes. See, so essentially in India, there are two types of bails. One is your bail post arrest, and one is your bail which before the arrest, which is called anticipatory bail. So essentially, what is the difference between the two is that anticipatory bail can be applied to by a citizen if he is apprehending arrest by the police in any FIR. And essentially, if that is granted, it means that even if the police wish to investigate from that person, he cannot be kept behind bars. The investigation has to continue as per the conditions laid down by the court in the anticipatory bail order. So that way, the citizen is approaching the court to protect his liberty and avoiding going behind the bars, even if there is an FIR or a crime or a suspicion against him. And when it comes to the other type of bail, which is the regular bail, which comes after an arrest, and you have to apply to the court again for it, stating that your custody behind bars is no more required and why you should be let out of the prisons and your liberty be protected thereafter.
Okay.
So these are the two basic types. So now your question: how do we proceed ahead, and what are the conditions which are factored in while granting or denying a bail? So essentially, when it comes to anticipatory bail, the requirements which are seen by the court, one are whether a prima facie case is being established against you. Essentially, one, because if there is a doubt of even an iota of doubt which is there basis the prima facie reading of the FIR as to its genuinity, the court is definitely going to be more inclined towards protecting your liberty by granting an anticipatory bail. That's one. Second primary condition while considering whether to grant an anticipatory bail is to see whether there is any need for custodial interrogation. So what does it mean essentially is that whenever a crime is committed, not necessarily that the investigation has to be done by putting the person behind bars, right? It can always be an investigation basis documentation, like a documentation is forged, or there is a fraud basis a money trail, or there is a financial transaction which has gone bad. So all these are a matter of things which are on document, which cannot be erased, which cannot be tampered with any which ways. So if the police have the documentation, that's sufficient for them to investigate in the matter. So, a second consideration by the court would be whether a custodial interrogation is necessary or not, or whether the documentary investigation is sufficient in the concerned case. So, that is the essential consideration. And the third consideration would be whether the person, if granted anticipatory bail, is at a risk of running away from justice. So, having these three considerations, anticipatory bail may be considered to be granted or disallowed by the court. When it comes to regular bails, which is bail after the arrest, uh, first and foremost factor for it is what type of offense is alleged against you. So there is a concept of default bail, which has been laid down by the Honorable Supreme Court in cases of bails. So where an offense has maximum punishment of up to 10 years, a default bail can be granted by the courts after if within 60 days the charge sheet has not been submitted. When we say these 60 days, it's not 60 days post filing of FIR, it's 60 days post arrest, date of arrest of the person. So once the person is arrested, if within 60 days the investigation is not closed and charge sheet is not filed, the arrested person can approach the court for a default bail. When it comes to offenses with punishment of more than 10 years of punishment, this timeline extends to 90 days. So essentially, these are the two types of default bails which a person can go in for once he is arrested. Uh, Beyond the default bail, if it is a regular bail which has been applied on merits, one essentially what you need to show is that now the investigation is over or not. Why is this necessary? Because essentially the court has granted your custody to the police solely for the basis of investigation. So now you need to show to the court whether you have cooperated with the investigation, whether any recovery or discovery which was necessary to be done at your behest in the investigation is done or not. And if that has been already been done, you need to show whether the investigation is practically for practical reasons has been completed with respect to you or not. So now once all these three things are put forth before the court, apart from that, which obviously no person who's accused of a crime is going to go ahead and say that yes, I've committed it, obviously. So beyond that, you have to go in for your defenses. You have to show whether the FIR is genuine or not, whether the FIR is actually proving any crime against you or not. So those would be the prima facie considerations which also the court will consider. And basis all these things, they'll decide whether the bail should be granted or not.
Okay, that was quite extensive, and I mean, yeah, definitely. Like you have categorized it particularly, so according to that, uh, I think all of us need to see what essentials are important when
Absolutely.
accepting or denying of a bail. So,
Absolutely.
how has the concept of bail basically evolved in the recent years, and what are such implications that that these the evolution has caused on the defendants?
Yes. So thankfully, the bail jurisprudence has been evolving pretty much in the past decade or decade and a half, I would say. Earlier, the situation was such that, so to be very honest, there are both pros and cons. I would say the pros are that it's evolving at a decent pace. People are, the judiciary as well as the investigating machinery are appreciating that liberty is the most important thing for any person and that needs to be protected. Earlier the situation was such that only the fact that a non-bailable offense has been alleged against you should be sufficient to just randomly come over, pick you up and put behind bars. But now thankfully that jurisprudence has evolved. If even if you have an offense against you of a non-bailable nature, if that punishment is below 7 years, the it's mandatory on the police to send you a notice, not randomly arrest you. They have to give the reasons for your investigation. If you don't cooperate, then again give a list of reasons for your arrest, and only then the arrest has to be made, and that would be a legal arrest. So that is a very welcome change, which is pretty much followed across the country now, barring a few exceptions. Secondly, it has also been laid down by the Honorable Supreme Court as well as the various high courts across the country that bail has to be the norm and jail has to be the exception. That is not followed in toto by the trial courts, unfortunately, but at least the jurisprudence is heading that way. So, on paper, at least, we are moving in a positive direction in trying to protect the liberty. On the hindsight, what are the cons is that unfortunately the trial courts don't really follow this principle laid down by the Honorable Supreme Court that jail has to be an exception. Many parameters come into picture for that. One is that if it's a financial fraud, for example, if the amount of fraud is large, it does play on the minds of the trial courts, and they do reject the bails in such cases. If it is a media trial, so-called media trial, that also does play on the minds of the judges, and many times it's seen that even if it is a good case for bail, as per the laid down principles by the Honorable Supreme Court, the bail does tend to get rejected. At the end of the day, we have to remember that judges also are human beings, and human factors do play on their minds. So that has to be considered while taking care of bail matters. But other than that, these pros and cons, I would say it's moving in a positive direction. It's not as bad as it used to be earlier. The only bad part now is that the courts are too burdened, to be very honest. And bail, which earlier probably could have been processed in a day. So, for example, if you file for a bail application in the morning, get heard by afternoon, and if the judge allows it, there were days that on the same day the accused would be out of jail. But now the situation is so bad and there's so much pendency happening that you do have to spend a few weeks behind bars, unfortunately.
So I think that is a bad news, though there's a
Yeah.
good news and a bad news. So
Yeah.
great. Yeah. And of course, I mean, since we are all talking about bail, so can you like share a particular notable case where bail was granted or denied, whatever the case may be, and what were the key takeaways for your client?
So unfortunately, I can't take names. I'm barred by the Advocates Act by it. But to give you a few takeaways, as I mentioned, many a times I have observed in my career that if it's a media trial, it becomes very tricky to get a bail because the pressure by the media, the public sentiment does play a big role on the trial court. And that becomes a big hindrance for you to get or deliver justice to your client. Having said that, it does die down. It's not that it's a forever pressure which has been created by the society or the media. And in such situations, I have seen that the key takeaway is that to be patient enough to approach the Honorable High Court by when the media pressure has also died down, and also the judges are more skilled to tackle the pressure, I would say. They are not uh, influenced by any sort of pressure over there. It doesn't matter who's speaking what, and they'll go by the key parameters laid down by the law, and that really helps. Many a times people do ignore that factor, and because they are very paranoid to get out, and maybe in that paranoia they end up making mistakes. Beyond that, I would say uh, in favor also is to show your prima facie innocence, as I would say, showing the prima facie loopholes in a case. For example, showing an alibi. If it is alleged that you are at an X place, if you can show that you are actually at Y, or if it is shown that, say, there's a financial fraud against you in a company, if you can show that you are not an executive director of that, which means that you don't have any control over the finances or the day-to-day operations. Showing these minor things do help a lot in getting you the bail, and that has been a very good takeaway from experience.
The key takeaways that you mentioned, how much time does it usually take to collect all of these evidences for proving someone innocent and for a grant of bail?
See, it all depends on how prepared is the client. So if the client is behind bars, whoever is representing him or her to the lawyer, how prepared are they with their documentation, their information, first hand information? It all depends on that. If they don't really have any idea about what has happened or what used to happen, then it becomes very difficult for the lawyer to get information. It does take a lot of time. They have to do a lot of to and fro with the accused, go behind bars, take. So there's a concept of relatives being allowed to go inside central prisons to talk to the prisoners, or have a telephonic conversation. So they have to keep going back and forth, take questions from the lawyer, ask the person, get back with information. So that's a tedious task. But if they are very well prepared, it's like a day should be sufficient. There have been multiple times that we secure anticipatory bails within a day. So
Oh,
it all depends on the preparation of the client.
right. That was a great insight. And like since we said that if a person is already might have to spend a few weeks before getting a bail into the jail, so what rights do these accused individuals have during this bail process?
Yes. So now, when we speak about people behind bars, they are essentially segregated in two types. One are the under trial prisoners, and one are the convicted prisoners. So essentially, the ones who are under trial are the people against whom an FIR has been filed, but the investigation is under process, or the charge sheet has been filed, but the trial is under process. So this is one type of people where there is no uh, judgment passed by the court that you are an accused or you are convicted for a allegation made. And the second type are the people who are convicted for whatever has been alleged against them. So these people are essentially segregated behind bars, and that's their basic right. So a person who is merely accused of a offense should not be kept with people who have been convicted for offense. So that's a basic right. Any prisoner will have one. Secondly, of course, they are eligible for all other basic fundamental rights. They get food. They are given access to medical treatments. When it comes to larger prisons, central prisons, the ones like in Bombay or Pune, Aurangabad, they have hospitals inside as well. When it comes to the convicted prisoners, their rights also extend to right to livelihood. So essentially, that means they get to work inside, they get to earn inside. So there will be smaller factories, there will be smaller jobs which are made available to them, like sewing clothes or uniforms of government officials, making chairs, making tables, working in small factories, and they are also paid for this. So they do earn per day on their basis of their work, and that becomes their livelihood. And that is what they take away when they come out of prison and try to start a new life.
But I think is there also a differentiation between the general public getting into the jail and the high profile cases? So is there a different treatment or is it
So
the
no,
same thing?
by law on the books, there's no different treatment. What actually does transpire is something that I can't really say on record. But one thing does differentiate when it comes to people with maybe higher influence or higher threat value, I would say, when it comes to owing to their maybe financial status or their public status, they do carry higher threat perception in the jail as well. Because
Right.
essentially, as I said, jail does comprise of seasoned criminals, hardened criminals, convicted criminals as well. So when you put a person with a very high financial or social pedigree, uh, it is considered that he is a high value target within the jails as well. And in such circumstances, that person might be given a separate cell just for the sake of his security. So, yes, that differential treatment might come in if the jail authorities feel that there is a higher threat perception solely because of his status in the society.
Okay. That was a great insight. Thank you for that. So how do you ensure that the a individual is adequately prepared for a bail hearing?
The best part would be, as I said, you should give all the possible instructions to your lawyer. Don't hold up anything. Don't try to show or don't try to be the judge of facts, whether what is necessary and what is necessary is not for you to decide. So, whatever is out there, good, bad, ugly, you should essentially state it all out to your lawyer, firstly. Secondly, as I said, get as much documentation as possible to prove your innocence. And thirdly, most often than not, what happens is that people try to delay cooperation with the police. So once you're arrested, there's not much that you can do in that aspect. It's better to be cooperating with the directions given by the court, and that helps you get out of the jail as soon as possible. Of course, having said that, it's a fundamental right of every citizen of our country that he need not depose against himself before any authority. So there's no burden on you to say that, yes, I've committed a crime. So that doesn't mean you're cooperating. Cooperation essentially means that if, for example, the allegation is that you have created a fraud in, say, you're a developer and you've created a fraud in ABCD scheme of yours, it's best to give all the documentation, all the financials of that scheme, and just show that you have not done anything rather than holding up documentation, rather than holding up information. So it's best to cooperate. It helps to show your bona fides and get you out on bail as soon as possible.
Great. So I've also seen some people, where uh, they get a kind of a tip where they feel that they might get arrested. It's presumed that they are going to get arrested, so they go absconding, and that's when. So in this period, can the lawyer apply for an anticipatory bail?
Yes, essentially, once a person is accused of a crime in an FIR and he's not yet arrested by the police, that is the duration between which you can file an anticipatory bail. It's your legal right. So, unfortunately, the word absconding is very loosely used by the police, especially. By law, an
Yeah.
absconding person is a whole new territory and definition. A person who is yet to be arrested and he is approaching the courts for his protection on anticipatory bail is merely going by the book, by the law. He cannot be considered as a person who's absconding. One. And secondly, for a person to be declared an absconder by law, it is a huge process. You have to issue a summons against him. If he doesn't turn up, then warrants. After warrants, you have to go ahead with proclamations, and then you can proclaim him or her absconder. So without doing any of these things, the police randomly just mention that you are absconding, and that's a very childish way to deal things with. There's no concept of absconding if you have applied before any court for your anticipatory bail. You're merely so going ahead and using your legal rights. And essentially, there's a very interesting judgment by the Honorable Supreme Court on this point, which says that if a person is merely uh, invoking all his rights of anticipatory bail, right? Be it from trial court, gets rejected to high court, gets rejected to Supreme Court. That cannot mean that he's a person who's absconding. He's merely approaching the necessary courts to get his legal rights and reliefs as mentioned by law.
Great. That was something I think that's like you said, that's a gray area, and a lot of people aren't aware of this. And
Yes.
that's how, I mean, we start projecting people that they are absconding, which, like you said, it's
Yeah.
not the case.
They are,
Just exercising
yeah,
a
they are
legal
not absconders at all. Yeah, it's legal. One
sense.
insight I would like to give what happens nowadays is that investigating machineries at times do try and play hardball. So
Okay.
they what do they do is that they get permission to tap the phone numbers of such people who are not available for arrest, and they have applied for anticipatory bail, and they try to show if someone's helping them out, they try to take that person in the investigative prerogative as well, by showing that he was helping a criminal on record to run away and whatnot. And these are all the tricks that the police will play to make sure that you are coming back uh, into the investigating boundaries, as to say, and they could arrest you.
But is this again like in the legal framework? Can they actually do it? Can they exercise this right
They
over
can't,
a
without permissions. They cannot tap
okay.
anyone's phone. One, and secondly, for example, if a lawyer is telling you to apply for an anticipatory bail and getting you all your legal rights, it can't be said that the lawyer helped him to run away and we couldn't catch him because of that. So
Right.
there are instances wherein police try to pull that off. By the way, they try to get the lawyer on the FIR as well by saying that he helped him to run away. So all these are tactics used by them which are not purely legal. If it goes to court, obviously the court does strike that down. But these are just problem areas that can occur for a person to handle.
Right, and I think these things also get you under pressure because we are already so traumatized by police, being around us and the way our police forces are. So they just kind of traumatize you, and in that pressure, you kind of tend to like say things out
Yes,
loud.
yes, yes,
So
yes.
that was an insightful
That is,
segment on
yes.
bail matters. All right, so moving to our check bounce cases. My first question to you, sir, would be that what are the key differences between civil and a criminal proceeding in check bounce cases?
All right. So, first and foremost, colloquially, it's called a check bounce. By law, it's called dishonor of a check, which otherwise people don't really find. Maybe even law students, I've seen lawyers as well trying to find check bounce in law books, and they don't really find it. So, it's called dishonor of check. And you have two remedies against it. One, approaching the civil courts for recovery of money, so for which you essentially have to file a recovery suit for whatever amount is pending from the person. And the second option you have is to go to the criminal courts under the Negotiable Instrument Act, which does give you a remedy against dishonor of checks. So, dishonor of checks, when we say, is essentially for negotiable instruments, as we call them. So, a check is called a negotiable instrument in India, and if any such negotiable instrument is dishonored, then you can approach the courts. Essentially, even if you approach the criminal court for it, this particular act is a quasi criminal act, I would say. It's not essentially an out and out criminal act, it's a quasi criminal act. And that is your second option to take if there is a dishonor of check.
Can you throw a little light upon what is a quasi criminal act per se, like for people to understand it better?
Yes. So essentially, when it comes to a criminal court or a criminal act, everything that you do or don't do does have implications with respect to your liberty being curtailed. That fortunately is not the situation over here. It is when I say quasi criminal, it means that there is a certain procedure, documentary or otherwise, which does follow before this is invoked. Like for example, if you have a dishonored check, you can't really go ahead and file a crime against that person. You have to give him a
Okay.
notice, allow him time to pay up that money. If the person still doesn't pay the money, then you have to go to the court, show a prima facie case, then the court will issue him summons. So there's no concept of an FIR directly being filed, and that's why I said it's a quasi criminal proceeding. It's not naturally a criminal proceeding as such.
Great, great. Thank you for, just simplifying that part. So how can individuals protect themselves from these fraudulent check transactions? And this has been, even though we are in an era of doing online transactions, still I think most of us are stuck in this loop forever. And
Yes.
so, please, how do we protect ourselves from that?
See, the best part to protect yourself would be, as you rightly mentioned, go ahead with digital transactions. If you still want to keep it physical, it's best to go in for a demand draft, to be honest, because that is money in the bank. But people avoid all these things. Why do they avoid digital transactions is a mystery. But when it comes to physical transactions, uh, demand drafts are not usually preferred because it comes at a cost. The bank charges a certain fee to come up with the demand for drawing that demand draft. But that is definitely worth the effort and the cost as against the trauma that you have to go through if at all the check doesn't get honored.
Yeah,
So that is principally these two steps would be your best possible protection against check dishonor of check situation. If the situation is such that worst case you do have to go ahead with a dishonor of with a check, it's best to document it, stating that whatever transaction you are getting into will be valid only if the XYZ check is being honored. That should be a trigger point to initiate the contract or the transaction. Because without which, if you are going to part with goods, if you are going to part with certain promises as by way of the contract, it becomes a very complicated scenario. Because then the other person gets a chance to show that the way in which you have delivered was fraudulent, the way in which you have delivered was defective, or maybe not up to the mark, or there were certain other things that they were expected to from you, and that's why they have stopped the payment. So it becomes a vicious loop from both the ends.
True. And I mean, I've also seen where there are a lot of businesses who work on credit basis. So,
Yes.
definitely, like once your credit period is over and you have not received your money, you have to, people are behind, their customers or the vendors, suppliers to give them the money back. But that doesn't happen. And that's why before turning them into, I mean, bad debts, this is when you kind of approach to procure your money back, they kind of give you this instrument, the check, to
Yes.
ki, post probably like a month
As a
or
security or something like that.
as a security, yeah, that don't worry, we release your
Right.
money within a month or exactly, and take this as a security. Otherwise, you can deposit and take it back. So this is the gap when actually the dishonor of checks actually
Yes.
happen.
Yes.
So
Yes.
it's not during the initial transaction, it's during this gap where the credit is
Yes.
not actually, the credit terms are not
Yes.
satisfied by the
Yes.
end, like the suppliers
Agreed.
or the vendors.
Agreed. So, at least what I suggest to my clients when it comes to complicated transactions which emerge from contracts and have payment terms in them is that I suggest that it's fine even if you want to give credit or give some time before the invoices are raised and the money comes in. But to protect that, you could have a significant amount as a deposit which then can work as your security. Let that money be in your bank. Don't wait for a so-called security check that goes to you. It's best to have money deposited in your bank. So, for example, you are anticipating that you are going ahead with a contractual engagement with someone wherein you are going to work for certain amount, which is going to be like 5 lakh a month. For example, you're going to work on certain thing, which is going to entail work worth 5 lakh a month. So that's 60 lakh of risk. Even if you want to go ahead and give some time period for the person to pay that amount, say you want to give a credit of 1 month, 45 days, whatever it might be, the best way to deal with situations is that if your credit period is 45 months, so 30 days is you giving service, then you raise an invoice, then you have a 45-day credit period. So you are showing your bona fides by giving this credit period. For the
Right.
person who is taking the services, for him to show his bona fides that he's eventually anyway going to pay you 60 lakh rupees for the year, it's best to take a 2 month deposit from him, 10 lakh rupees, because that way you also secure yourself. Like if you give a service of 30 days and then thereafter 45 days is the credit period, if the person doesn't pay you back, you always have that 10 lakh with you from which you can deduct this amount. And if the person
Right.
anyway in that 30 plus 45 days has the bona fides to pay you, he must have paid by then already. It works best for both the people who honestly want to work with each other rather than taking security checks, which are absolute misnomer by law. I'll touch upon that in a while. Why is it a legally extremely bad idea to take security checks?
So, I mean, yes, please tell us. I mean, we can continue on that.
Funniest part is that even most of the lawyers will miss this. Uh, is that essentially if you go down to the bare definitions of a negotiable instrument and when is a negotiable instrument payable. The most important part, so people do understand that it has to be a legally payable debt. That is the definition every lawyer will have by hearted by now. But that's not all. So you need to understand the nuance that if you are giving a security check, which means that the day on which you are exchanging the check. So today I'm exchanging a check with you for something which is to occur in future, right? That if I don't pay and if we continue with the transaction and after 2 years there is no money in my bank, money being paid by me, you please deposit this check and then you can recover the
Right.
money. So is that legally payable debt payable as of today? The answer is no.
No.
And there is a judgment by the Honorable Supreme Court which says that the day on which the check is exchanged, if the debt is not legally payable on that day, that security check is of no use. You can't really go to court, even if it is dishonored. So that's the
Okay.
worst way to deal with situations. I have defended my clients for hundreds of crores for this, fortunately for them, but unfortunately for the people who worked in a very bad way. They couldn't really recover their money because, as per law, it's not a negotiable instrument in the first place because the debt was not legally payable on the day on which the security check was exchanged.
Wow, wow. I think all of us are doing it the wrong way and taking
Yes.
these, we actually feel, I mean, the general public feels that, taking these security checks is something as a security and, your money is not lost. But like you
Yeah.
said, it's
It's a
actually,
bad idea.
it's a bad idea.
all all
Great.
all the person on the other end requires is a good lawyer. So
Absolutely. Yes. A good lawyer like you, definitely.
thank you. Yeah.
So, so what are the typical defenses used in these dishonor of check cases, and how are they actually successful?
So one, as I mentioned, you need to just show first 50% of the cases under negotiable instruments come by way of these security checks. So they
Right.
become absolutely bad. That itself is a sufficient defense. Second defense is essentially these exchanges happen over exchange of goods, some or the other business. So valid delivery of goods is something that if you can disprove, then definitely you can get your defense in a negotiable instrument act. Secondly, thirdly, if you can show that in toto the debt was not legally payable. So, for example, many a times the contracts when it comes to delivery of goods do say that if there is a delay beyond a certain point, then there's no payment. Like that delivery is invalid delivery. So if that you can prove, because many a times industries can't wait. So if an industry requires a certain product in 10 days for production, it requires it in 10 days only. It can't be after 15 days. So if your contract says that if it is 11th day onwards, it's not a valid delivery, then that you can definitely show, even if the opponent has actually delivered the product at your factory, if it's lying in your factory, it doesn't really matter, even if you are in the possession of that good. You can show that it wasn't a valid delivery, it wasn't a legally payable debt, and that is good enough defense for you to go ahead and defend yourself. And lastly, I would say that largely one thing also people need to consider is that once summons is issued, so as I told you previously, a FIR is not the recourse in a dishonor of check or a check bounce matter. It's you have to go by a private complaint to a court. The court is going to issue notice uh, to the person who's accused of dishonoring the check. In such a situation, many people miss out that that order of the court of issuance of notice in a dishonor of check is a final order, which by law means that it can be challenged in revision. So, a magistrate court which issues the order of issuance of notice against a person against whom there is a dishonor of check initiated, that person ideally can approach the sessions court under revision, and you can there itself take all your defenses and try to strike down that notice. So, there's no question of a trial, there's no question of a defense, there's no question of going through that rigor. But that also 90% of the times people miss out on.
Right. Yeah, I mean, this is also something I've never heard of, people actually exercising this. And
Yeah,
I think everybody's going to get really amazing insights from this session
thank
regarding
you.
all the pain points that we're discussing today. So,
Yes.
since you were saying that, a FIR can't be filed directly, and
Mm.
you need to go to the court first, and that's how the issues notice. Sorry. Yes.
Yeah.
So, can you lay down uh, the process of filing a dishonor of check, and what are the expected timelines for this process?
See, once you get an intimation of dishonor of check, you first need to give a notice to the person, concerned person. And as per law, there are statutory periods laid down. for the notice to be given. Once the notice is issued and the notice period is over, so within a certain amount of time, you have to give the notice. That's the first requirement. You can't give that notice after 6 months or whatever. 30 days is the period. So within 30 days of dishonor, you need to give the notice. Once the person receives the notice, he is again by law given a statutory period, breathing period, to pay that money. So which is again 15 days. And if
Okay.
that again period is exhausted by that person and he does not pay, then you can approach the magistrate's court having jurisdiction. So competent jurisdiction wherever it lies. So it essentially depends on the place from which the check is drawn. So wherever it is, the local magistrate will have jurisdiction. You have to apply for a private complaint under one section 138 and 141 of the Negotiable Instruments Act in the concerned magistrate's court, and the court will give you a hearing, and then the process will begin.
Okay. So, so it's like 30 days, you have to send a notice, then 15 days, you got to wait for the other person to pay up and then move ahead.
Correct. Correct.
Great. All right. So, yes, I think there we sum up our segment two of check bounce cases. So, now moving on to the third pain point, that is the inefficiency of judiciary and the police force in India.
Mm.
So what are the primary causes of the delay in India's judicial system, and how can it be addressed? Like you also mentioned before in our previous segments, that there's too much of load on the judiciary, and
Yes.
that is why, like in the bail matters, also people are not getting the kind of immediate justice they should
Yes.
be getting. So,
Yes.
please, can you throw some light upon this?
Yes. So when we speak about delay, it's essentially because of three pillars of our justice delivery system. One is obviously the judiciary, the judges. Secondly, it's the police, and thirdly is us lawyers. So of course, with respect to us lawyers, it's a very uh, done and dusted line, tarik pe tarik, which usually the lawyers do take. And yes, if they stop that for whatever reasons, that's going to help in speeding with the speed of the justice. Having said that, the rest of the two pillars, a lot has to improve on both the ends, and that is essentially clogging up the pace of our justice delivery. We do come up with fancy lines like justice delayed is justice denied, but like by that logic, justice is always denied in India. There's no speedy justice. Let me be very blunt with this. We might be having the best of the legal brains. We might be having a very, very detailed legal system which tries to take care of our liberty, but when it comes to this statement, if justice is delayed, then it means it's denied. Then in India, in 99% of the cases, it's denied because our justice delivery is extremely slow. Reasons for that are multifold, to be very honest. One, if we start from the judicial angle of it, the judiciary is absolutely, absolutely overburdened. It is immaterial how good uh, a judge is with respect to his legal acumen, but if you throw hundreds of cases at him or her in one working day, it's impossible for that human being to hear all those matters, give just do justice with those hearings, and then deliver justice as well. It's not possible. So the first and foremost issue is overburdening of judges, which means the ratio of judges to population is pathetic in India. We can have all sorts of feel goods about ourselves that we are developing at a rapid pace. We are no more a third world, blah blah, and we have changed overnight in the past, overnight or in the past decade or whatever it might be. But our justice delivery is very bad when it comes to burdening of judges. The ratio is pathetic. If you compare it with developed nations, we are probably 10 times behind, at least, if not worse. So that ratio first needs to improve. One. Uh, Secondly, and that ratio is across, like from magistrates court, sessions court, high court, supreme court. The ratio of judges to the population is very, very bad. Like, for example, if there are 30 Supreme Court judges for 130 crore people, we need to pity them. Like, how much are they going to do and how are they going to deliver justice? So, and there's no point in just cribbing and criticizing them. So that's one bit. Second is the infrastructure. To give you an example, I am sitting right now in Pune as I speak to you. We are in Maharashtra right now. So the Bombay High Court, which principally began, which is the epicenter of justice delivery, as we can say, when it comes to this state. That building was made available for the Bombay High Court, I think, in 1860. It's still running there. We are independent for more than 75 years. No government has taken any effort in giving any type of infrastructure to the judiciary. They are rather being superheroes by using the same limited infrastructure and trying to deliver justice to so many people where the population is 100 times more. So that is our second problem. The infrastructure to the judiciary is abysmally low. There is no effort which is taken by governments to give adequate infrastructure. That is the reason the citizens are suffering. We are not getting justice, but that unfortunately people don't see through. What we see through is, oh, police are so inefficient, the judges are so bad, the courts are so inefficient. In Marathi, there's a saying, "Courtachi pairi chadu naye," which means that no one should ever have to step onto the court's footsteps. So that is not going or not thinking and understanding the issue. The core issue is that the ratio of judges is very bad to population. The infrastructure is pathetic. So, as I said, 1860 we got our current High Court, and right now, as of 2024, the Bhumi Pujan has happened of the new space for the High Court. It's not. We don't know how many years it will take for it to be built, to be handed over, and to be functional. So it's that bad. You can't take 160, 170 years to give one building to the biggest epicenter of your justice of the state when we have 12 crore people staying here. So the situation is bad also owing to this. Thirdly, I would say the police, which are prima facie involved in the justice delivery from the point go, like right from the FIR to investigation, charge sheets, helping the courts in understanding the evidence, giving evidence, all that has to be done by the police. There also the situation is equally bad. Firstly, the police system in our country is such that it was devised and designed by the British. It was not supposed to be designed in a way that they are friends of the citizens. Unfortunately, we are still continuing with it. So, just to give you an example, probably you will be going to any other developed country for your vacation. If you need any help, if you see a policeman, you approach the person first to get help. In India, if you see a policeman, you run away. You just first turn your back and go in the other direction. So that's the
Yeah,
basic problem. So the basic that's so it's as minute as that. The first instance should be that the police are there for the citizens. They are there as their friends. That unfortunately is missing in the entire ethos of policing. And unfortunately, we are into the British Raj type of policing, wherein the police are the tormentors as we see them, which they might not be in toto as well, but that's what the image has been because of whatever experiences the people have had over the years. Now let's go to their issues as well. Why are they the way they are right now when it comes to their functioning? Again, the same logic. If you expect a small tin shade of 10 by 10 or like 20 by 10 feet, wherein you cramp up a couple of dozen of policemen and expect them to do everything under the sun, like they are expected to do those VIPs, the politicians will be coming, the VIPs will be coming, so they'll be expected to do their bandobast. We'll have hundreds of festivals in India. They are expected to keep the decorum on the streets. They are also expected to be available for the citizens if they approach the police stations. They are expected to file FIRs. They are expected to investigate, go on the spots of crime, do all types of fancy forensics that we see in US sitcoms. And then again, make sure that all of it is preserved, documented, taken to courts, and then proved to court as well. All this, if you are going to expect one team, one set of people sitting in extremely inhuman conditions, then it is stupid on our part to expect that they'll deliver. They also need a very good infra. One, the police stations are absolutely inequipped in India. No government puts any effort in giving state of art police stations to the policemen. One. Secondly, the number of policemen has to increase come what may. You can't expect the same set of people to be doing everything that I just mentioned. Investigation has to be a separate affair with a separate team. Coordinations with the prosecution and the court has to be a separate team. law and order has to be a separate team, but that in India is not the situation. So just blaming the police that they are not doing what they are supposed to do is not going to help. They will do what they are supposed to do if and only if they are also subjected to better infrastructure and better working conditions. So in India, we might be having if, for example, there was a suicide that I read in Pune from a big four company by a young girl, which had a huge hue and cry when it came to the working conditions.
Right.
You won't be even be in a position to imagine in what working conditions do these policemen work. And then we expect that they should be functioning absolutely as per our international standards that we see. So that's not going to happen. As long as their working conditions are not taken care of, that's not going to happen. So that is the second reason because of which there is an extreme delay in justice. There is an extreme delay in investigations, and not just delay, that eventually does also lead to very substandard investigation, which helps the defense, and the acquittal rate in India is extremely high. There's very little conviction in India.
And when I'm hearing this, I feel now we are getting clear on the other side of the picture as well. Right now, we're just seeing one side where we feel
Correct,
that we are not being given the kind of justice that we should, right, as citizens of India.
correct,
Definitely, if
correct,
we are humans, even they are humans on the other side. And
correct.
I mean, but I still have this question that if the citizens of India should not hold the judiciary and the police accountable for all these inefficiencies, who should we hold accountable for all of these things?
Firstly, firstly, the government. To be very honest, unfortunately, there in the past 75 plus years of our independence, no one has taken the onus to create state of art policing machinery and a state of art judicial machinery. In every developed nation, that is the backbone of their country because that is how the entire country is in check. Like if you have phenomenal law and order situation, the tourism spikes, the business spikes, the overall quality of life in the country spikes, the country just flourishes. That unfortunately has not happened in India at all. The policing machinery and the judicial machinery, no one has bothered to look into any political leader. You can come up with any fancy name that you want to. But I can assure you that no one has taken those efforts. That's why I gave you an example of Maharashtra. That also is unfortunately the situation of the entire country. It's not just about one state. The ratio is very low of judges, of the police, their infrastructure is poor. So whom is to be blamed is it's the government. And as I see it from a practical standpoint, many a times, as you of course also will be aware, your viewers will be aware, many a times politicians are subject to pending criminal matters. And this delay in the justice delivery helps them. So clearly, it's not in their favor to have a very speedy justice delivery system because half our political ecosystem will be wiped out by that logic. So that could be one of the reasons why there is no government initiative which is taken in giving us world class police and judicial machinery.
But yeah, that's what I mean. Even it's I don't know. At the end of the day, I just feel that it is us only because we are only electing such people to
Correct, correct. So
come
that was my
and
intention to give you the insights, right? People need to think before they come to conclusions. They need to
right.
understand everything.
I think at the end of the whole conversation, the loop comes back to the citizens themselves. So, I mean,
Yes, most
you
definitely.
have to hold yourself accountable, I think, for all of the things that are happening.
Most definitely. Most definitely. So what, and of course, with it will also happen is, see, if you give good infrastructure, good pays, lesser working hours to these segments of the society as well, many good youngsters will aspire to be policemen, will aspire to be judges, and their output will be way better, obviously. So that will also trickle down eventually in a generation or so to create a very good ecosystem for a country. Right now, if you don't give that, people are going to only fancy being an engineer, a doctor, a software guy, or whatever it might be. If you want honest and good citizens to aspire to be policemen and to be judicial officers, we also need to make sure you give them good pays, you give them good infrastructures, let them feel like they want to be there. So that will help us as a country also.
Absolutely, so well said about that. And like you were saying that I had one of my previous episodes, I had a lawyer who's into mentoring and coaching of judicial aspirants. So there she mentioned that there are lakhs of people who are aspiring to become judicial officers, but due to the system of also passing these exams is a constraint again, that people are not coming out in batches that should come out in. So I
Yeah.
mean, what is your take on this? Like, definitely at the end, if we see at the end of the tunnel, we have, like you said, the ratio is very low, but again, what are we doing to also pull in that kind of an input into the system? So I mean, what are your thoughts on that?
So one, there has to be some parameter for getting the judges in. Uh, and unfortunately, other than examinations, when it comes to lower judiciary, so I'm speaking about the magistrate as well as the district court category. Unfortunately, you can't just say that if you have X number of years on your sanad, that is your license, you can become a judge. That way, every person will just wait for 10 years after their degree and then they'll become judge, which is not good for our society. So there has to be some parameter by which you gauge their quality. And fortunately or unfortunately, this present exam is the only way that we do it. I would definitely believe that there should be UPSC level scanning of these people, because uh, in our country, the unfortunate part is that a person who goes through that level of scanning of UPSC level takes some decision which goes bad, then it comes to court to be decided by a person who has not gone through that scanning. A judge is a person who must be giving some exam which is not as rigorous. So we complaining about that exam is not very ideal. I would believe there has to be extremely extreme scrutiny before making a person a judicial officer. When it comes to constitutional courts, that's the Supreme Court as well as the High Court. Yes, exams don't play, because there you can't really get a person pass an exam and sit on such a high office of judicial officer. There, obviously, experience one matters. That's why the most experienced judicial officers eventually become High Court and Supreme Court judges. And on the second end, I think, which is not used as much, we can tap in more over there, is reputed and successful lawyers need to be tapped more. So there is a provision in our country that lawyers with standing in the bar can directly become High Court and Supreme Court judges. So that doesn't happen very frequently in India. In Supreme Court, we have barely like less than 10 instances of such lawyers becoming Supreme Court judges directly. In High Court, it does happen. In all the High Court, senior advocates do pick up for the bench, but still, I think that can be tapped in more. That way, you get a person with extreme expertise over law sitting at the right office to deliver justice.
True. And so like you're saying that the current exams are not sufficient. We need more stringent,
Yes, yes,
scrutiny for.
yes, yes.
Okay.
So
So
fortunately or unfortunately, I'll give you practical example of this. Why have I said this? So like in today's day and age, a person with 7 years of experience after license, that is their degree and sanad, can apply for a magistrate's exam, and that exam, as I said, is not of a grade of which a UPSC aspirant might be having to face. That way, a person becomes a judge pretty easily in comparison to these people. But fortunately or unfortunately, say a cheating case under our prevalent or even the new laws of BNS and BNSS which have come up, those will go before these people with an experience of barely 7 years. Like thousands of crores of fraud will amount to a case of cheating that will go before this person who barely has any understanding or experience of law. You can't then expect justice to be delivered in the right sense over there. So if you want to keep the experience level low, then at least keep the examination scrutiny level high. Both can't be low, is my
low.
essentially my input. Yeah,
No, and absolutely. So that's very logical. At the end of the day, we also need to see what kind of the quality of justice that's given also needs to be really of a high value. So
correct.
definitely. So, are there any successful models or or best practices from other countries that you think that India can adopt to overcome all of these inefficiencies?
With immediate effect, we can definitely adopt. So all the countries and principally the International Court of Justice as well, and all the planning commissions of various countries do have this readily available data of number of judges is to population. So if we can try and first reach that ideal level of ratio with respect to number of judges to population, that is our first step towards trying to deliver justice. Then the second situation will come: where do these sit? Then the situation will come: are there enough policemen or staff to help them deliver justice? All that will keep on falling in place. First, let
Right.
that ratio of judges to population be improved, which is a matter of just allotting funds, nothing beyond that. You just need to make sure that you are allotting funds for the salaries of these people, and first get that ratio up. Once you get that ratio up, things will slowly fall in place, and we'll have a better situation wherein the justice is definitely way speedier than what it is right now.
Right, and definitely that makes sense. And I mean, if we as individuals we practicing in a private setup, we also look forward for that monetization and the motivation that we
Correct,
get from monetary
correct,
compensation. So why not
correct,
the government officials for that matter?
correct, correct. Because see, what happens is it's like expecting a very good doctor to take care of a government hospital. Will he?
Right.
He's not. He will might as well work in a private hospital, come up with his own hospital, and do
Yeah.
justice to his level of skill with when it comes to monetary input. I agree. There might be people who will say, okay, if I can earn 10 rupees, I can settle at 7, but at least give me 7. I am ready to work for the government. You can't expect them to settle at 1. So, if you want quality people, especially these are the two conditions: law and healthcare, where you need the brightest minds. You can't
True.
expect substandard minds to take care of things and then expect a world class judicial system.
Yeah, and at the end of the day, these people are doing social service. I mean, earning
Correct,
less and also doing social service.
correct,
So I think they need to be
correct,
adequately compensated for the kind of work they are doing.
correct. Absolutely, absolutely. Yes. So, it first step comes from allocating funds and increasing the number of judges, quality of judges, number of judges. Then maybe the infra can follow. Then everything else can follow.
Absolutely. Yes. And thank you for all of those insights. And it was like a mind blowing, I would say it was a wake up call for all of us that for
Thank you.
the, I mean, for ages that whom are we holding accountable? I don't think they're accountable really of all of the injustice that's happening. We need to really look through past, the things that are there and see the reality also of the situation. And I think
Yes.
this session has given us that insight. Absolutely. Thank you so much
Yeah.
for giving us
Thanks a lot.
all that wake call.
Thanks a lot. I'm
So,
glad I was of some use.
no, absolutely, sir. Absolutely. So, I think the moment of truth finally approaches. And my concluding question shall definitely expose a daily struggle that unites us all. And that is something related to the toll plazas that we generally cross across when we are traveling. So, what rights do the citizens have if they encounter the unnecessary delays or the harassment at the toll booths? And I think that's become a common practice now. Even the other day, I was traveling and there was a car ahead of me who probably did not have a fast tag or had less of funds in their account, and they were literally like arguing with the people out there at toll, and they were just not ready to budge. So I mean, me, I at the end of the day, if I am standing behind this car, I only have an option to honk, and there's not
Yeah.
no other thing that I can actually do right now. So, I
Yeah.
mean, to for someone else's inefficiency of not having right funds, or why am I to suffer at the cost of my time? And whereas I've also heard that there's a rule saying that more than 10 seconds you need to cross the toll within 10 seconds of
Yes, that
entering.
is correct. So, see, coming to your last point that you can't spend a certain more than certain amount of time in that alley or you need to pass it within that time basically indicates that it's a no stopping zone.
Right.
So you can't just come and stop or park or wait in that lane is the basic logic of it. One. Secondly, if someone is not following the law and that is disturbing others is something which unfortunately others can't do much. Though authorities here, the people who are given the responsibility of taking care of that toll plaza have the only option to make sure that that person pays or at least gets the car out of the way. Beyond that, there's very little that can be done because it's like you can't really come up with rules for exceptions, right? The day your rules start get governed by exceptions, then life becomes very difficult. So exception has to remain an exception. So just because someone, see, out of 1,000 or 10,000 cars, one is not paying up and holding up certain lane, you can't really tweak your entire system and your rules for that particular exception. So that unfortunately remains an exception. The only thing that can be done is to make sure that that person is taken out of the lane as soon as possible by the authorities. Beyond that, the question of being harassed by tolls, as you said, that to a great extent now is being taken care of by fastags, I would say. Initially, the personal interaction with that staff was way higher. The harassment was way higher. And also the transparency was way lower because you never knew what type of receipts were being given to you, whether those receipts are going on record or not, and whether that toll collected was going in the private pockets of the person or it was actually being handed over to the concerned account. That is to a great extent is being taken care of by the fastags which have come up across the country. Nonetheless, but unfortunately, this is a very gray area since there is no judicial authority or control over this particular mechanism because this is entirely exclusively in the hands of the executive. Uh, the tenders are allocated for various roads to be built. In those tenders, a time period, first a cost is mentioned, a time period to build is concerned, and a time period to recover that cost is mentioned. So it's expected that the developer recovers the cost in that particular time limit, and for which accordingly the toll will be calculated, right? It's a gray area that they many a times get extensions on those limits by just showing that in the past 10 years, for example, if that person had to collect the toll, he'll come up and show to the government that in those 10 years I had to spend equal amount on repairs and maintenance of this road. So now I need further extension of that 10 years to recover my money. Then they'll come up with interest costs. They'll come up with various other components. And as I said, it's a gray area. We would like to believe that the executive and the politicians are behaving fairly while giving those extensions, but we don't really know. So that remains a gray area, and the citizens unfortunately have to keep on paying every time the toll is extended. But by norm, by rule, by the tender procedure, it is a limited process. 10 rupees to be spent in 1 year to build the road, and 5 years you get to recover that 10 rupees. It's simplistically made like that. But unfortunately, that 5 year period will keep on getting extensions by showing something on record that it is justified to give the extension. On the hindsight, though, the citizens, all these, since these are public funds, the citizens can go under the Right to Information Act and try and get those informations for their record.
Okay. But again, like you said, that extensions definitely yes. I mean, they are taking that we can see. But even after paying hefty toll charges, I don't think the kind of road infrastructure that we should be getting is
Yeah,
it's
missing.
really bad. It's messy.
Yes,
Absolutely.
yes. Yes. Yes, it's messy. One, it's missing also most of the things. So many a times in India, what is happening now in this past, I would say 2 5 years, definitely that we are getting good quality roads when it comes to intercity travel. Intracity is still bad, but intercity, if you have to travel, world class roads are coming. Pune, Bombay, Atal Setu has come up. Bombay to Delhi, Agra, wherever the roads are good, but we are absolutely missing out on a point that it's not just about the roads. You have to have infrastructure for people to stop, to rest, to go to restrooms, to have fuels. If you don't
Right.
have that, the number of accidents are going to increase. So if you are going to give unsafe roads of excellent quality, they are practically useless. So such
True.
things we are not considering. Those costs we are not putting onto the developer who's supposed to develop that infrastructure. Uh, as I said, we will never know whether it was fairly allowed or not, or whether it was a favor done by some quid pro quo done under the table. But that remains a problem with our country when it comes to road infrastructure and tolls.
Right. I think this gray area is again, I don't know for how long is it gonna go on, and I mean, yeah, the I think the music. It's at the end of the day, the music has to be faced by the citizens only. Nothing can be done
Citizens,
about
yes, yes, and the numbers are too high and too huge. Therefore, the syndication happening on that level is very, very strong and powerful.
it. True. Absolutely agree to that. So, yes, I mean, it was an amazing session. And, sir, thank you so much for your valuable wisdom and expertise. That has definitely empowered us all today. And to all the
And
listeners, remember, knowledge is the power, especially when you're navigating these complex legal landscapes. So please be aware of whatever is going on, be aware of the legalities, and then, get into what you're getting into. So, yes, thank you
yes,
so much, sir, for an
my
enlightening.
pleasure, my pleasure.
So, your contributions to the legal field are truly inspiring, sir. And we are glad that we could have you on the show and spread your knowledge to all our listeners who are listening to this episode. And yes, thank you for tuning in to Nuskas with Anushka. Join us next time for more inspiring conversations and valuable insights from experts in their fields. Don't forget to like, share, and subscribe. Follow our page on Instagram and spread the word. Until next time, stay curious and stay receptive. Thank you.